Welcome. As artificial intelligence permeates every facet of our modern lives, from medicine to transport, we arrive at a critical and contentious crossroad, the courtroom. Today, we explore the profound question of whether AI can, or indeed should, play a role in the administration of justice. The implications are monumental, touching upon the very bedrock of our legal principles: fairness, accountability, and the nature of judgment itself. To debate this, we have two distinguished guests. Dr. Evelyn Reed is a renowned legal technologist and ethicist at the forefront of AI development. She advocates for a future where technology enhances legal proceedings, arguing it can rectify long-standing human failings within the system. And offering a powerful counter-perspective is Judge Arthur Vance, a senior judge with an illustrious 30-year career on the bench. He is a staunch defender of the human element in jurisprudence, expressing deep-seated reservations about outsourcing moral reasoning to a machine. Dr. Reed, if you would be so kind as to begin.
Thank you, Julian. It is imperative that we begin this discussion by acknowledging an uncomfortable truth. Our current justice system, for all its noble aspirations, is demonstrably imperfect. We operate under the strain of overburdened courts, exorbitant costs, and the persistent, insidious specter of human bias. Countless studies have substantiated the fact that judicial decisions can be swayed by factors as arbitrary as the time of day or the outcome of a local sports game. This is not a robust foundation for justice. I do not propose that we replace our judges with silicon counterparts. Rather, I advocate for the integration of AI as a sophisticated tool to augment human capabilities, to introduce what I term data-driven jurisprudence. The primary, and perhaps most compelling argument for this integration is the mitigation of human bias. A properly designed AI can analyze the factual matrix of a case and compare it against thousands of precedents, with a degree of objectivity that human beings, with our inherent cognitive shortcuts and unconscious prejudices, struggle to achieve. It can act as a check, flagging potential disparities in sentencing or bail recommendations that correlate with race, gender, or socioeconomic status, thereby forcing us to confront and correct our own systemic failings. Secondly, the efficiency gains are simply staggering. Consider the discovery process in complex corporate litigation, which can involve millions of documents. An AI can analyze this mountain of evidence in a matter of hours, identifying relevant documents and patterns that would take a team of paralegals and junior lawyers months to uncover. This expedites trials, reduces crippling legal costs, and clears congested court dockets. Finally, let us consider what some call, quote, predictive justice. AI tools can perform risk assessments for bail and parole hearings based on vast data sets, identifying the statistical likelihood of recidivism far more accurately than the gut feeling of a single judge. This leads to more consistent, equitable, and evidence-based outcomes, reducing the lottery of which Judge 1 happens to appear before. The goal is not to dehumanize justice, but to deliver a more reliable and equitable form of it, where it is not delayed or denied due to the inherent limitations of human cognition.
Judge Vance, your opening statement.
Dr. Reed speaks of data, efficiency, and consistency. These are the metrics of a factory, not a courtroom. Justice is not a product to be optimized for output. It is a profoundly human and at times messy process that involves grappling with ambiguity, context, and a quality that no algorithm can ever possess. The entire edifice of AI in the courtroom is built on a dangerously flawed premise. My most fundamental objection lies with what technologists euphemistically call the black box problem. A defendant has the constitutional right to confront their accuser and to challenge the evidence presented against them. How does one confront an algorithm? How can a defense lawyer mount a meaningful appeal against a decision when the reasoning behind it is locked within a proprietary, computationally indecipherable system? This is not just a technical hurdle. It is an affront to the principle of due process. Accountability vanishes when the decision maker is a block of code. Furthermore, Dr. Reed's assertion that AI mitigates bias is, I fear, dangerously naive. It does the opposite. It launders and legitimizes pre-existing bias. These systems are trained on historical data, decades of case files and judicial decisions. And what does this data contain? It contains the residue of every systemic prejudice our society has ever harbored. The AI will not learn justice. It will learn our patterns. It will learn that certain neighborhoods are policed more heavily, that certain demographics are sentenced more harshly. It will then replicate these biases, but with one crucial difference. It will cloak them in a veneer of objective, technological infallibility. It is the very definition of garbage in, gospel out. Finally, and most crucially, the law is not merely a set of rules to be applied mechanically. It requires moral reasoning, the weighing of competing values, and the exercise of discretion. Should a desperate father who stole a loaf of bread to feed his starving children receive the same cold, calculated sentence as a professional thief? The letter of the law may say so, but justice demands context, empathy, and, on occasion, mercy. An AI operates on correlation and code. It has no capacity for compassion, no understanding of the human condition, and no grasp of the spirit of the law. To cede this ground is to create a sterile, reductive, and ultimately inhumane system that erodes the very meaning of a fair trial.
Thank you both for those compelling opening arguments. Judge, let me press you on a point Dr. Reed made. She argues for AI as a tool to overcome demonstrable human failings, like inconsistent sentencing for identical crimes. While you rightly champion human empathy, how do you defend a system where justice can be a lottery, depending on which judge you get, or as the studies suggest, even what that judge had for lunch?
You raise a valid and troubling point, Julian. The variability in human judgment is the system's most persistent ailment. Judicial training and sentencing guidelines are our ongoing attempts to remedy it. However, the imperfections of human justice are known. They are appealable, and they are, at their core, human. We can question a judge's reasoning. We can challenge it in a higher court. The flaws are transparent, at least in principle. The flaw of an algorithm is opaque and absolute. I would rather contend with the known, albeit frustrating, fallibility of a human mind than submit to the inscrutable, unyielding verdict of a machine that cannot explain itself. The cure Dr. Reed proposes is, in my estimation, far more dangerous than the disease.
If I may, Julian, the judge speaks as if the flaws in AI are permanent and insurmountable. He is describing the technology of yesterday. The entire field of explainable AI, or XAI, is dedicated to solving the black box problem. Refusing to use this powerful tool because it is not yet perfect is akin to refusing modern medicine because it has potential side effects. We manage the risks. We do not abandon the cure.
Dr. Reed, that brings me to my question for you. The judge raises a crucial point about due process. Even with explainable AI, if the explanation is a 10,000-page printout of statistical correlations, how does that align with the fundamental right of a defendant to truly understand and challenge the case against them? Is a right to an explanation meaningful if the explanation itself is beyond human comprehension?
That is the central design challenge, and it is a matter of regulation and policy as much as it is of technology. We must legislate standards for transparency. An explanation does not have to be a raw data dump. We can design systems that produce clear, natural language summaries of the key factors that drove a recommendation. For instance, an AI risk assessment tool could state, the recommendation for denying bail is based on 3 primary factors: a high similarity to past cases that resulted in failure to appear, a lack of stable employment, and 2 prior convictions for a similar offense. This is a starting point for a human judge to review, and it is infinitely more transparent than the unarticulated gut feeling it is designed to supplement, not replace. The human remains the final arbiter, but they are now armed with better, more consistent data.
A summary is not an explanation. It is a conclusion masquerading as reasoning. It tells you what the AI decided, but not how or why it weighted those factors. Justice must be seen to be done, not merely calculated behind a digital curtain. A defendant deserves to hear the reasoning from a human being who has looked them in the eye and weighed their humanity.
So let us bring this to a fine point. Should AI, if used at all, be strictly limited to administrative tasks like document review? Or do you see a legitimate advisory role for it in the critical areas of sentencing and bail?
Its role should be exclusively administrative. Let it schedule dockets and search for keywords and documents. The moment it begins to advise on a person's liberty, we have crossed a perilous ethical line.
That is an unnecessarily timid approach. To deny a judge a tool that could provide a more accurate, bias-free risk assessment is to willingly accept a less just outcome. It must be an advisory tool in all areas, provided the final decision rests firmly with the human judge.
We have time for your closing statements. Judge Vance, you may conclude.
We have spent this time debating efficiency versus empathy, data versus wisdom. The proponents of this technology promise a utopian vision of flawless, efficient justice. But this vision is a mirage. In our quest for technological perfection, we risk sacrificing the very soul of the justice system. The core dangers remain undealt with. Bias, not eliminated, but dangerously encoded. Accountability, not enhanced, but completely obfuscated. And the erosion of the moral and empathetic reasoning that is the sole purview of human consciousness. The efficiency of a machine can never, and must never, be allowed to replace the wisdom of a human being. Let us not sacrifice real, human-centered justice for the cold illusion of technological certainty.
Dr. Reed, your final thoughts.
Judge Vance eloquently defends a tradition that I, too, respect. But we cannot afford to romanticize the status quo, which is rife with proven inequity and inefficiency. The goal has never been to replace judges, but to empower them. The objective is to provide tools that help counteract our known cognitive biases, that manage overwhelming caseloads, and that ensure a person's fate is not decided by the arbitrary luck of the draw. This is not a flight of fancy, it is a tangible path toward a fairer system. To resist this evolution is to knowingly perpetuate the injustices we already have. We have a moral obligation to responsibly and cautiously harness the power of technology to build a more just and equitable society for all, not just for those who can afford a lengthy, human-powered legal battle.
Dr. Reed, Judge Vance, I thank you both for a robust and deeply enlightening discussion. You have laid bare the central conflict of our age, the promise of technological objectivity versus the irreplaceable value of human judgment. The code for our future is being written as we speak. It falls to all of us to decide what values, mercy, efficiency, wisdom, or data, we choose to program into the future of justice. Thank you for watching.